Right. Okay. So just to let you know that the event is now being recorded. Thank you, everyone, for attending this session on ecocentrism and international law, organized by the International Law Group at Brunel University London. Thank you so much for the three panelists, for Sara, Professor Sara Vido, Professor Otto Spijkers, and Professor Kevin Heller, for being the panelists this afternoon and discussing your finding and your research and your thoughts and reflections on this particular very, very interesting topic of international law and ecocentrism. I will start by giving a sort of small bio on all discussants, and in order, I think I mentioned it in my email, we'll start with Professor Spijkers, who will discuss issues in relation to the right to a clean and healthy environment, and then we'll move to Professor Sara Vido with her reflections on the court's implementation of ecocentrism perspective on decisions by the courts, regional courts, and then we move to Professor Heller, who will discuss issues in relation to ecocide and the definition of ecocide by the expert panel. The recording will then be uploaded on our usual YouTube site. Now, let me start with a brief bio for all our speakers. Professor Otto Spijkers, we know that was professor of international law at Wuhan University's Chinese Institute of Boundary and Ocean Studies, as well as its Research Institute of Environmental Law, and founding staff member of its International Water Law Academy. He's no longer a professor at Wuhan. In fact, he is about to start a new post in January at Leiden University, but he's still managing director of the Chinese Journal of Environmental Law. Prior to joining Wuhan, he worked at the Utrecht Center of Water, Oceans and Sustainability Law and Netherlands Institute for the Law of the Sea of Utrecht University, Netherlands. He was visiting lecturer inter alia at Peking University Law School, Xiamen University China International Water Law Program, the Università degli Studi di Salerno in Italy, and the Université Catholique d'Afrique Centrale, Yaoundé, Cameroon. He wrote his doctoral dissertation entitled The United Nations, the Evolution of Global Values and International Law at the Grotius Center for International Legal Studies of Leiden University. He has published hundreds of articles and books. He has worked as public services coordinator at the Peace Palace Library as international consultant and coordinator for the United Nations International Law Fellowship Program, as intern for the Appeals Chamber of the International Criminal Tribunal for Rwanda, and as an intern for the Office of Legal Affairs of the United Nations headquarters. Otto studied the basics of international relations at University of Sussex. He then studied international law at University of Amsterdam, New York University School of Law as an exchange student, and the Hague Academy of International Law, 2009 session. He studied philosophy at the University of Amsterdam and the University of Malta as an exchange academic. He obtained a diploma approfondito de langue française as well. So that's for Professor Spijkers. We now move to Professor Sara Vido, who is an associate professor of international law at the University of Ca' Foscari of Venice, Italy, an affiliate member of the Manchester International Law Centre. Her latest book is Violence Against Women's Health in International Law, published in 2020 by Manchester University Press. In 2021, she co-edited a report on criminalization of gender-based violence against women in European states for the European Commission. And again, last year, published an interesting article on ecocentrism and international law from a COVID-19 perspective. She is also a rector's delegate for Holocaust Memorial and Remembrance Day and Gender Equality, and she's also a Manchester International Law Centre affiliate of the UK Women in International Law Network. Last but not least is Professor Kevin John Heller, currently Professor of International Law and Security at the University of Copenhagen Centre for Military Studies and Professor of Law at the Australia National University. His books include the Nuremberg Military Tribunals and The Origin of International Criminal Law, published by OUP in 2011, and 4 co-edited volumes, including the Oxford Handbook of International Criminal Law, that's OUP 2018, and most recently, Contingency in International Law, on the possibility of different legal histories, again, OUP 2021. He currently serves as a special advisor to the ICC prosecutor on international criminal law discourse. He's also an academic member of the Doughty Street Chambers in London and serves on the advisory board of the Bar of Human Rights Association of England and Wales. So that's a quick bio summary of our 3 panelists. I'll give the floor to Professor Spijkers to start with. So it's about 10-15 minutes each. And I think, as we said earlier, if you want to share, which I think Professor Spijkers is going to share a PowerPoint. Over to you, Otto. Thank you.
And Dr. Hobbs, just before Professor Spijkers starts, just to say that also Dr. Piero Sullo from Brunel University London, Dr. Mardikian and Dr. Luoma from Brunel University London are in the audience. So if they can be promoted to panelists, then Dr. Hobbs, as the main convener of the event, maybe you could try to do this. And of course, for my part, also to welcome all the members here in this interesting talk. So for my part, everything is clear also for the event to kick off. And Professor Spijkers, we are ready to hear your words.
Okay, thank you very much for giving me the floor and for inviting me to contribute to this interesting discussion. Indeed, my focus will be on the human right to a healthy environment. And that may seem a bit of an awkward choice because human rights are by definition anthropocentric. They're all about human interests. But I hope to explain that it is still interesting to think about anthropocentric and non-anthropocentric views together to contrast them against each other. So my view is about my presentation is about human right to a healthy environment, and I wanted to have a look at the resolutions that have been adopted affirming the existence of this right, first by the Human Rights Council and then by the UN General Assembly, and then share with you some reflections about this right. So first, this right was adopted in a resolution of the Human Rights Council in October of last year, and it was voted on with an overwhelming majority, but with some votes in abstention, some abstentions, including Russia, China, and also India and Japan. So in this resolution, the Human Rights Council recognizes the right to a clean, healthy, and sustainable environment as a human right that is important for the enjoyment of human rights. This is kind of a curious phrase, because if something is a human right, why would it need to be emphasized that it's also important for the enjoyment of human rights? That seems a bit awkward. And if you look at other parts of the resolution, you also see this sort of ambiguity as to whether a healthy environment is a precondition for the enjoyment of other human rights, or whether it's actually a distinct and independent human right. So there's always this confusion as to whether which of the two it really is. And then, of course, the United States, which was itself not a member of the Human Rights Council when the resolution was put to the vote, it expressed very strongly its reservations on the website of its Geneva mission to the UN. And basically it comes down to the view that the UN does not, that the US, sorry, does not believe there is a basis in international law for such a right. So essentially in the US view, it does not exist or does not yet exist. And also in the US view, it should not come into existence. And then later on, the UN General Assembly also voted on the same right at the end of July of this year of 2022. And to, well, the surprise of many, the US actually voted in favor this time. Russia and China still abstained, as did some others, but the US voted in favor. And some of the ambiguities that were still in the Human Rights Council resolution, they are now done away with. You don't see them in the General Assembly version of the resolution, which is, in my view, a great plus, a great progress. So paragraph 1 simply states the UN General Assembly recognizes the right to a clean, healthy, and sustainable environment as a human right. It's no longer important for the enjoyment of human rights, it's just a human right. And the other ambiguous phrases have also been omitted from the resolution if you compare it with the Human Rights Council version. And the US, to everybody's surprise, voted in favor, but then on its website, again, there were a lot of reservations to the right. So it's quite clear that the US, although voting in favor, is not particularly enthusiastic about this right. And the same is true of other countries like the United Kingdom and others. So if you look at the explanations of the vote, you see that most of the states, or many of the states that voted in favor, did so without much enthusiasm, and acknowledging and stressing that a lot of open questions remain. So, but the thing is, and this I find very interesting, the thing is that we now have these two resolutions, and it is the General Assembly and it is the Human Rights Council, at least officially, that have now affirmed a human right to a healthy environment as a human right. And of course, you can say, as the UK and the US have done, that these are just political resolutions. They're not legally binding. They are just political aspirations. They don't change the law. They don't affirm what is the law. They have no legal significance. Of course, maybe formally that's true, but in practice, it doesn't really work that way. We just think of the United Nations Declaration on Human Rights, which just yesterday celebrated its anniversary, or two days ago, rather. That has been of immense influence to international law, despite its non-binding character. So often these resolutions, the soft law, is seen as a kind of Trojan horse that sort of enters the world of international law unrecognized, and then it explodes and shows its true potential, its destructive potential. So now I wanted to share with you some reflections about this human right to healthy environment. The one thing is that even though it's been now affirmed by the Human Rights Council and the General Assembly, much is still unclear about what exactly it means. And I think kind of illustrative of this is that at the very last minute, the word safe, or sûr in the French version, was deleted from the Human Rights Council resolution. That really was a last-minute decision. And during the informal negotiations, concerns were raised that the French translation of safe, so sûr, was too vague, and that this word could form the legal basis of unexpected obligations for states. So the sponsors therefore decided very quickly to remove this word from the resolution. But does such a hasty and last-minute adoption of a controversial adjective really solve the problem? Or is there something more fundamental going on? I mean, it's no trivial matter that we should now speak of a human right to a clean, healthy, and sustainable environment, and not a human right to a safe, decent, non-polluted, favorable, suitable, adequate, decent, or wholesome environment. Those are all adjectives that have been suggested in the literature. The choice of adjectives is not a trifle, of course. It's an essential issue. I mean, international law, and we all know this, and law in general is all about the words that we use. And that's not the only outstanding problem, the still outstanding problem. I mean, no one will deny that a healthy environment is important and that it deserves a particularly high legitimacy status from an emotional and even moral point of view. But that's not necessarily a reason to label it as a human right. After all, a new human right can only have an impact on reality if it is defined in such a way that it can be invoked by an individual person in specific and concrete situations that directly affect his or her daily life. Without such a strict and concrete applicable definition, the right to a healthy environment risks remaining a practically irrelevant addition to the category of these third generations of human rights. Of course, that does not mean that the right must be freed from all ambiguities before it can be meaningfully applied in practice. I mean, just like all other human rights, the right to a healthy environment, once adopted, will crystallize further through adjudication and other dispute resolution mechanisms. And the same happened to the rights to equality, free expression, and so on. And those are also just as vague, and we are only now starting to understand what they mean in detail and in their concrete application. And there's yet another reason to give importance to the specific choice of adjectives, and this one is essential to the theme of today's panel. So words like safe or suitable or adequate, they all suggest that the environment exists for us human beings. It's adequate for us to live in. It's safe for us to live in. We humans have an interest in protecting our environment because of the goods and services that it provides to us. As long as the environment is in good enough shape to do so, some might consider it suitable or adequate or safe and so on. But on the other qualifications like clean, healthy, and non-polluted, they allow for a less anthropocentric and more ecocentric approach. After all, even if there were no people at all in this world, the environment could still be considered clean, healthy, non-polluted. But would it not be better then, if we prefer this ecocentric approach, would it not be better then to talk about a right that belongs to nature itself rather than a human right to a healthy environment? Or must we regard a healthy environment as a common concern of humankind rather than exclusively as a right pertaining to individuals, as a human right? And the adjective sustainable raises particular questions that are linked to what I raised before. So how can a currently living individual, like me or you, be entitled to a sustainable, what does that mean for us to have this claim? The relationship between human rights and the concept of sustainable development, defined as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. That is a relationship that has preoccupied academics for many, many years. But again, no clear consensus in academia exists on how to best understand this relationship between the concept of sustainable development and human rights. Instead of recognizing a human right to a sustainable environment pertaining to currently living individuals, that is the present generation, we might also recognize a right to a healthy environment for future generations. So we are not entitled to a sustainable environment. They are entitled to a healthy environment just as we are. In my view, that makes a lot more sense. But in any case, simply giving individuals an individual human right to a sustainable environment does not really solve or settle these issues. But I'm coming to my conclusion now. Regardless of all these philosophical debates that will probably never be resolved, this human right to a healthy environment has already proved itself to be very successful in actual litigation. And since I'm from the Netherlands, I cannot help but refer to the Urgenda litigation and the litigation of Friends of the Earth Netherlands against Shell, a major oil company that was headquartered in the Netherlands, and now they escaped to the UK. So now they're headquartered in the UK. So both these cases were very much based on human rights, including the human right to a healthy environment, but also the human right to life. And this kind of litigation, climate litigation based on human rights, is actually proved to be very successful. And I doubt that climate litigation based on nature rights or rights of future generation will achieve the same kind of success. I think that is what I wanted to say. So I thank you for your kind attention, and now I pass the floor to Patrizia again, I guess. So thank you.
Thank you, Professor Spijkers. If you want to share your your view, thank you so much. Thank you for that very good start and challenging thoughts on the right to a healthy, clean and sustainable environment from the point of view of ecocentrism. I'll pass the floor now to Professor Sara Vido to continue the discussion on this interesting topic. Thank you. Sara, over to you.
Good afternoon, everyone. Thanks so much, Patrizia, for organizing this event and inviting me. Thanks a lot to Brunel University. And I'm so glad to actually have discovered that Piero Sullo, a friend of mine, is also part of this university. So a lot has happened in these past years, and I'm really happy to join this event and share the floor with such distinguished colleagues. And thanks, Solon, also for being here and hosting the event. So my presentation concerns ecocentric approaches to human rights law, developing human and no human right to healthy environments. So following actually the thoughts by Otto through interpretation and cross-fertilization. So the purpose of my presentation is to reflect on the incorporation of ecocentric approaches to law in the arguments proposed by a regional court, such as the Inter-American Court of Human Rights, and how to cross-fertilize the jurisprudence of the European Court of Human Rights. I will first, very shortly, talk about the inherent anthropocentrism of both international and international human rights law. Secondly, I would like to present what ecocentric approaches to law means according to my research, so as a theoretical framework that is useful in order to appreciate the importance of the evolution of a right, human and no human right to healthy environment. Then I will move forward to analyze the jurisprudence of the Inter-American Court of Human Rights and how to cross-fertilize the jurisprudence of the European Convention on Human Rights, and also to challenge the inevitable anthropocentrism of all human rights treaties. And also to conclude, I will move towards a reflection on substantive principles, which I'm defining as ecocentric requirements, including intergenerational equity that was already mentioned by Otto before, and the principle in dubio pro natura. But let us start first, to stick to the time, to the inherent anthropocentrism in international, and more specifically in international human rights law. Saying that international law, and more specifically human rights law, are inherently anthropocentric seems quite obvious. But it is not if we consider that indeed the anthropocentric approach to international law was an achievement until some decades ago. Indeed, in 1978, an author wrote about the anthropocentric theory of international law as a basis for human rights. And the author caught precisely the point of human being as beyond the borders of states as traditionally conceived. And also, and it's very interesting to read this 45 years after this piece, that I quote, the anthropocentric theory of international law calls for a functionalist approach for that law and its institutions in the fulfillment of the needs of man's, obviously not a gender neutral language at that time, of man's planetary existence. Planetary existence of humanity at that time might have implied the realization of the humanity rights, including the right to food, water, but also clean air. And nowadays, this has gained momentum thanks to the better appreciation of the inclusion of human beings in a holistic system, which we can define in general terms as environment as us. So human rights are then ontologically anthropocentric because they have been conceptualized in this way. And also it's interesting to read other debates back to the 1990s in a publication by Eichen that reflected and actually asked a quite provocative question. are human rights drivers of the environmental crisis as they encourage and justify unsustainable use of the land? Or are they an essential element in the search for a way out of the crisis? At that time, this author felt that it was sort of, let's say, naive to suggest a paradigmatic shift in the legal reasoning, but it was back to the 90s where environmental law was at the very beginning. And what seems clear, indeed, is the role of both international organizations and courts in interpreting legal instruments in force and in determining a paradigmatic change in perspective. Second point of my short presentation is about ecocentrism as theoretical framework. Well, ecology as a science shows high levels of complexity, and clearly it's not possible to entirely explore this kind of complexity from a legal point of view. According to De Lucia, ecology is always already a worldview and not only a theory. And he analyzed and proposed a biopolitical analysis of ecosystem approach in order to overcome the binarism, anthropocentrism, ecocentrism. But despite this argument and the application of biopolitics to the analysis being extremely fascinating, the purpose here is to focus more on ecocentrism and whether it could be a useful tool to describe the complexity of the evolution of new environmental concerns. So in my perspective, ecocentrism is a theoretical framework and actually more a paradigm or a paradigmatic shift, according to the definition by the philosopher Thomas Kuhn. According to him, there is no necessity of new empirical data. What is needed is a conceptual reorganization of otherwise familiar material. And so he thought about the analysis of normal science under a paradigm, then crisis, then revolution, then a new paradigm. So we can argue now that we are at a stage in which crisis, plural, pollution, climate change, slow onset emergencies, though I prefer the definition of slow violence that was introduced by Rob Nixon to describe this persistent deterioration of the environment, and revolution from civil society and from courageous interpretations by courts and new thoughts, even though only through soft law, are occurring, and the new paradigm is gradually affirming among multiple difficulties. And the ecocentric paradigm I'm developing is actually inspired by Plato cosmology and takes into consideration modern concerns caught by ecofeminism, with the need to disrupt existing patterns of discrimination and disrupting the classic binarism. So the approach is ecocentric and ecofeminist in my view, and it should be conceived in an intergenerational perspective, considering the needs of humanity and of all elements of nature. The work and this idea of whole and the environment as us, as conceptualized by Christopher Stone so many years ago, cannot be understood properly, though, without acknowledging the patterns of domination and repression we see in present society. And that is why I found in ecofeminism, which has never actually been adequately analyzed from a legal perspective, is important because it explored and highlighted the gender-powered imbalanced relations, the root causes of discrimination and domination. Sorry if you hear some sounds in the background, but it's my toddler that she's trying to listen and interact with me at the moment. Sorry for that. So yes, dear, yeah. The theoretical framework, as I was saying, is particularly important. And I would like to move forward to the jurisprudence of the Inter-American Court of Human Rights that has begun to incorporate ecocentric legal reasoning in the recent decisions. Indeed, in a landmark advisory opinion of 2017 and the contentious case decided in February 2020, the court derived an autonomous right to a healthy environment from Article 26 of the American Convention of Human Rights. In the court's view, the right to a healthy environment protects nature, even absent, and Otto was actually emphasizing this also before, protects nature even absent evidence of possible risk for human beings because of its importance to the rest of the living beings. And then we have this very inspiring judgment of 2020 against Argentina, and it was brought by an indigenous community. And this ruling marked a significant step forward for the protection not only of indigenous people's rights, but also it went well beyond because it interpreted the human rights instruments as living instruments that follow the evolution of current times and living conditions. So how to take the lesson of these inspiring judgments and the advisory opinion? Well, we know that the European Convention of Human Rights is, as all human rights instruments, anthropocentric by default, we could say. And also what we have seen, and it was considered as a very progressive attempt, was what we call greening human rights. So the protection of the environment is indirect, since the beneficiaries of the obligations states have are only those individuals whose rights are affected. So the duty is not about protecting the environment, but protecting humans from significantly harmful environmental effects. And also the European Court of Human Rights has given the states a wide margin of appreciation when rights of individuals are affected by interventions by the states. So how to overcome procedural and substantive limits in the jurisprudence of the European Court of Human Rights? Well, there are several attempts that can be used. In particular, the Inter-American Court of Human Rights has taken the challenge to see the exercise of jurisdiction by the state over the activities carried out that cause the harm. No, so not on the victims, but on the activities that cause the harm. So cross-fertilization is possible, is not absolutely new, even though it was not courageous enough to be applied in environmental issues. And there is a tendency on the part of international courts and tribunals to adopt common approaches in two ways. One is ascendant and one descendant. So from domestic courts to regional human rights courts and vice versa. And from a substantive point of view, to conclude this presentation, there are some principles that can guide the legal reasoning and interpretation, such as intergenerational equity and the principle in dubio pro natura, which has made its way in Latin American countries. And these are ecocentric environmental parameters to measure states' obligations in the field. Intergenerational equity is not contrary to the affirmation of the rights of nature and to ecocentric moves. And also I'm arguing in favor, and I don't have the time to explain that, to a new principle, an interstitial principle using the words by Loeb, that is in dubio pro futuris generationibus. So when there are doubts, the interpretation, the rules must go in favor of future generations. Of course, and I conclude, from a substantive point of view, there is always the possibility to adopt a new hard law or soft law, but also hard law. For example, protocols or treaties on the right to healthy environment, which are, however, subject to long negotiations among states. So the examples are the proposal of an additional protocol to the European Convention on Human Rights, and also a protocol to the Charter, which will be devoted to the right to a safe, clean, healthy, and sustainable environment and social and economic right. And I conclude with a quote by the former president of the European Court of Human Rights, Robert Spano. He said, the European Convention on Human Rights is by definition an anthropocentric document. That's its focus. This is an interview that he had with Philip Sands in 2022. And he said, I think that it is unrealistic to think that the issues we are facing in the modern day environmental debate will be resolved through the anthropocentric proxy human approach, where we are always asking to what extent we should preserve the environment to serve a human per se, and where we never give the environment a standalone rights-based status. So that's what he argued. And also, just a final sentence about a possible protocol to the European Convention. That would just be giving me, as a judge, a tool to deal with the different dynamic, where the anthropocentric nature of the right is potentially diminished by opening up the possibility of humans being more aggressively involved in taking care of their environment. Thank you so much for the attention.
Thank you so much, Professor Vido, for that interesting presentation on ecocentrism, especially your thoughts on ecofeminism. Hopefully we'll touch upon again later on. Just before I move the discussion and give the floor to Professor Heller, the panelist discussions will open up to all participants to ask questions. So if you want to start posting your questions on a Q&A section, please feel free to do so. Or of course you also have the possibility of raising your hands later on. Professor Heller, I'm giving you the floor to your discussion on ecocide. Thank you.
Thank you. It's very nice to be here. Quick caveat, I'm appearing just in my academic capacity and not as a special advisor to the Office of the Prosecutor. So in the immediate aftermath of the Vietnam War, there were, as you probably know, considerable efforts at the international level to criminalize ecocide. In fact, in the late 1970s, debates at the UN made it seem possible, even likely, that ecocide would be added to the Genocide Convention. Now, that obviously never happened, and for the next 4 decades, the dream of criminalizing ecocide was kept alive primarily by scholars, people like the late, great Polly Higgins, and by environmentally minded NGOs like the one that she co-founded, Stop Ecocide International. Recently, though, ecocide has reappeared on the international agenda. Not only are more and more scholars and NGOs taking an interest in criminalizing ecocide, international organizations and even a few states are, perhaps somewhat tepidly, beginning to take the concept seriously. Now, that interest, I think, is due in no small part to Stop Ecocide's decision to commission a panel of 12 eminent legal scholars and practitioners to come up with a working definition of ecocide. That definition was published in 2021, and I'll read it very quickly. For the purposes of this statute, ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. Now, I obviously don't have time today to analyze the panel's definition of ecocide in any great detail. Let me simply offer a few thoughts about its strengths and its weaknesses. So let me begin by acknowledging 3 things that I like about the panel's ecocide definition. First, I applaud the panel for providing specific definitions of key terms in the actus reus of ecocide, such as severe and widespread. The similar war crime of causing excessive damage to the natural environment, Article 8.2b4 in the Rome Statute, if you're interested, doesn't define those terms. And it's equally welcome that the panel waded into the very difficult and contentious debate over how the environment itself should be defined, endorsing a definition that isn't perfect, but is essentially all-encompassing. Second, I appreciate that the panel adopted a disjunctive approach to the prohibited environmental damage or threat of environmental damage, quote, severe and either widespread or long-term, instead of Article 8.2b4's widespread, long-term, and severe. And I agree with the panel that the war crime in the Rome Statute sets the damage bar too high. Third, and finally, I think that the panel's definition works pretty well for acts that are unlawful under either international or national law. With regard to unlawful acts, the crime is genuinely ecocentric. A perpetrator is guilty of ecocide as long as she knew her act would be substantially likely to cause the requisite environmental harm. full stop. So they're good things. But there, I think, my agreement with the panel ends. So my critique of the definition starts with the claim that I know that the panel itself rejects, namely that there's almost no chance that the ICC will ever actually prosecute a defendant for committing ecocide. And I say that for three interrelated reasons. First, I think states will be reluctant to even formally adopt the Ecocide Amendment. Per Article 121.3 of the Rome Statute, 81 state parties would have to vote in favor of adoption. Now, that's certainly not impossible, but there have been very few successful amendments in the court's 20-year history. Second, and more importantly, I think, because we are talking about adding a new crime to the Rome Statute, ecocide would apply to only those states that actually ratified the amendment. And that's Article 121.5 of the Rome Statute. I would respectfully suggest that very few states in which ecocide is occurring or likely to occur would be willing to ratify an ecocide amendment, given that such significant environmental harm rarely takes place without the complicity, or at least the toleration, of the government. And here I think the aggression amendments are a useful analogy. Only 43 states have ratified the amendments since they were adopted 11 years ago. And it's very difficult to find any states among the 43 that are actually likely to commit aggression. Now, third, and finally, even if the ICC did have jurisdiction over an act of ecocide, the Office of the Prosecutor would find it very difficult to prosecute the act successfully, given the panel's definition of the crime. And that's what I want to spend the rest of my time talking about. The most significant problem with the panel's definition concerns how it treats lawful acts that otherwise satisfy the actus reus of ecocide. In other words, acts that are lawful, but are still likely to cause unacceptable damage to the environment. Now, many, if not most, environmentally destructive acts will fall into this category. As the panel itself acknowledges, international law generally leaves environmental protection to states. And as we all know, very few states adequately protect the environment, much less deem certain kinds of acts, particularly economically beneficial ones, categorically unlawful. Now, with regard to acts that do not violate either international or domestic law, the panel's definition of ecocide is explicitly anthropocentric. Even if the act is likely to cause the requisite environmental damage, the perpetrator will still only be guilty of ecocide if she acted, quote, wantonly, defined as, quote, reckless disregard for damage, which would be clearly excessive in relation to the social and economic benefits anticipated. Now, I reject this anthropocentric cost-benefit analysis on both conceptual and practical grounds. I'll return to the conceptual problem at the end. Let me focus now on the practical ones. Simply put, I don't think the wantonness requirement works in terms of either its actus reus or its mens rea. With regard to actus reus, I'm very skeptical that the prosecution will ever be able to prove beyond a reasonable doubt that the environmental harm of a lawful act was clearly excessive in relation to its social and economic benefits. I don't have time to develop the critique in any detail. I've written on it elsewhere, but suffice it to say here that there's no evident way to apply either side of the proportionality analysis with the precision necessary for a criminal prosecution. Projecting environmental harm, particularly over the long term, is a notoriously difficult task, and determining the social and economic benefits of a lawful act is likely to be even more difficult, given that the very concept of benefit is inherently subjective, determined far more by ideology than by quantitative markers. Now, perhaps you're more confident than I in the ability of the ICC's judges, very few of whom have any scientific or economic training, to make that cost-benefit analysis. I would simply note that nearly all scholars, left and right, question whether the judges can reliably apply the proportionality analysis required by the war crime, Article A2B4, balancing an attack's anticipated military advantage against its expected civilian damage. Those assessments strike me as far more determinate than the ones required by the panel's definition of ecocide. And of course, it would not be enough for the judges to conclude that the actus reus of the wantonness requirement was satisfied. They would also have to decide that the perpetrator, quote, recklessly disregarded that fact. That mens rea means that the perpetrator must have been consciously aware that her act would cause clearly excessive environmental damage, but acted anyway. Now, that's a subjective test, so it would not be enough for the judges to conclude that a reasonable person in the perpetrator's position would have known that the damage would be clearly excessive. That's negligence, not knowledge. The perpetrator herself must have known, and that seems unlikely, Given that she was engaging in a lawful act, by definition, it seems far more likely that she will have unconsciously inflated the act's economic benefits and/or minimized its environmental costs. So, from a criminal law standpoint, then, the panel's definition of ecocide has some notable flaws, particularly for lawful acts, but to some extent, even for unlawful ones. My most significant problem with the definition, however, is conceptual. Simply put, I don't think the crime that the panel has defined deserves to be called ecocide. Ecocide is, as the very name implies, supposed to be ecocentric. The crime is supposed to view the environment as an end in itself, worth protecting even when environmental harm benefits humans. Yet the panel's definition deliberately excludes from ecocide any, I emphasize that, any lawful act of development that is sufficiently beneficial to humans, even one that the perpetrator knew with absolute certainty would cause severe and widespread and long-term damage to the environment. Now, a crime that prohibits knowingly causing environmental harm, only when that harm isn't anthropocentrically valuable enough, is not, in my view, ecocide. And that isn't just my idiosyncratic opinion. Let me read you a very different definition of ecocide. Acts or omissions committed in times of peace or conflict by any senior person within the course of state, corporate, or other activity, which cause, contribute to, or may be expected to cause or contribute to serious ecological, climate, or cultural loss or damage, or destruction of ecosystems of a given territory. Now, that is an ecocentric definition of ecocide, unlike the one adopted by the independent expert panel. And it's a version of ecocide, interestingly enough, that was once promoted by the Stop Ecocide Foundation itself, the foundation that convened the independent expert panel. Now, let me be clear in conclusion. I genuinely understand why the panel thought it was necessary to dilute the definition of ecocide originally endorsed by the Stop Ecocide Foundation. States would never accept a truly ecocentric definition that makes no room for, quote, beneficial human development. But here's the thing. For all the reasons I've noted, states are not going to accept the panel's diluted version of ecocide either. So the panel has endorsed a crime that will never be prosecuted and that undermines ecocide's expressive value by making it explicitly anthropocentric. In my view, that's the worst of all possible worlds. If the Rome Statute is going to criminalize knowingly causing environmental damage, only when that damage does not adequately benefit humans, we should amend the Rome Statute to create a new crime against humanity of, say, wanton destruction of the environment, a peacetime equivalent to the war crime in Article 8(2)(b)(4). After all, crimes against humanity are explicitly anthropocentric. I'd be wholly in favor of such a crime. But we should not enshrine the panel's inadequately ambitious definition of ecocide as the fifth core crime of international law. Indeed, I don't think we should refer to that definition as ecocide at all. A concept more oxymoronic than anthropocentric ecocide is, in my view, difficult to imagine. Thanks.
Thank you very much for that challenging reflection, Professor Heller, on the definition of ecocide. Okay, so I'm just going to, I can see one hand is raised and it's been raised for a while. So I'm going to ask Simon Saruba if you want to pose your question to the panels first, and then I'll open up for more questions.
Good evening.
Good evening, Simon.
Yes, I want to ask that as we know that in the ecocentrism, the most affected part is the plastic pollution. And we should work regarding it, just like the GPML Global Plastic Marine Litter Program is working on it. And I also want to know that can we explore it through the organic solutions regarding that? Can we promote the tourist? Can we aware the tourists regarding organic solutions during their tourism, so that they can find themselves the solutions regarding the plastic pollutions and the correlation between the environment friendly tourism. So in one way I want to ask that can we find the organic solution regarding the control of the plastic pollution, and can we relate our tourism sector with the plastic pollution also?
Thank you, Suman, for that question. So I'll open up to any of the panelists. So if I can understand it correctly, it concerns the plastic pollution in the context of tourism in the ambit of ecocentrism. Does anyone have any thoughts on this particular issue? Otto, maybe?
Yeah, okay. So when I was still at Wuhan, one of my PhD students, he was looking at plastic pollution. And yeah, one of the big controversies or debates relating to plastic pollution is whether we need a new treaty specifically focusing on combating plastic pollution, or whether it should be dealt with via the many different venues and avenues that already exist. So then human rights law would be one possibility. The Law of the Sea Convention is particularly relevant. That would be another possibility. So to not to make a new treaty, because that's always the sort of Pavlov reaction that many states have. If there's a problem, let's make a new treaty. But maybe for plastic pollution, that's not the way to go. And maybe it can be dealt with in many different ways. And then human rights law would definitely be one of these ways. But yeah, I don't think, I mean, plastic is a threat to us human beings more than to nature itself. So this is not a problem that concerns nature. It's very much a problem that concerns us. So I don't really see how an ecocentric approach to plastic pollution would be better or more effective than an anthropocentric approach to plastic pollution.
Thank you, Otto. Sara, Kevin, do you have any thoughts to add to that regarding plastic pollution and ecocentrism?
Yes, thank you so much for this interesting question. I don't have like a very straightforward answer to that, but I agree with what Otto was saying, but I would also add that there are effects on no human beings and nature with regards to plastic pollution, and we see that in the oceans. So what like applying an ecocentric approach to law in this specific context would mean, well, this is a matter that really deserves some research, and thank you actually for raising it. What I have in mind now is that this approach, and just a bit of brainstorming, is that when we deal with plastics, and we could see that in the European Union as well. So when we see plastic, we see also like production and economic opportunity. So when there is a shift towards ending plastic, and single-use plastic, for example, derived from a directive that entered into force soon after the pandemic, means also to consider the approach of the European Union was, oh, there is an economic potential for like abandoning single-use plastic and to move forward towards a new economy without single-use plastics. Which, of course, as also Kevin was saying about the reaction of states, this was the smart move in order to have this kind of directive accepted. However, it would have been better to consider the reduction and even the elimination of some kind of single-use plastic from an ecocentric perspective, because in this way it would have benefited not only humans, but also no human being. And in terms of tourism, that is crucial. We see that in Venice, I'm afraid, with the pollution from plastic, and I'm sure that you have other examples to raise. In that case, also guidelines for transnational corporations that incorporates those kind of interests and values would be a possibility. But as I said, this is a matter that should be really a topic of huge research. But I agree with Otto with the unlikelihood of having a new treaty. Thank you.
Thank you both, Otto and Sarah. Kevin, do you have anything to add? Otherwise, I can give you the floor to the next question. I can see Peter Committee's hand has been up for a while. So Peter is one of our postgraduate students. Peter, I'll give the floor to you to ask a question.
Yes, thank you, Prof. Can you hear me?
Yes, we can.
Okay, thank you. I'll go straight to the question. I think I'm more interested in the part that deal with ecocide. Yeah, I basically want to ask, like, okay, fine, the speaker made a lot of, good observation, especially with regards to the difficulty in prosecuting the crime of ecocide from the amendment of the, of the statute, of the ICC statute, and to the challenges that the Office of the Prosecutor will have. Now, my question is, must we look at it from the angle of the ICC? Must ecocide be tied to the International Criminal Court? Whenever we discuss ecocide, must we be looking at, the statute, establishing the ICC, how we could feature it into the ICC, the difficulties the ICC will have. The ICC is bedevil with a lot of difficulties. Yeah. So must ecocide, or any other emerging crime be viewed from the ICC perspective? Is international criminal law limited to the ICC? Fine, the ICC is more or less, the most important body for international crime for now, but must everything be limited to the ICC? Because if we keep limiting the discussion to the ICC, we might not make any progress with regard to ecocide. Is there any alternative, especially when a crime becomes of a serious nature? Must it be limited to the ICC? That is my first question. Then my second question is, do you think the fact that if the crime of ecocide is to be prosecuted, the fact that is basically, the defendants or the respondents are basically going to be, global north countries, do you think it has any effect on it not sailing through the ICC statutes? Like, put it in another way, if most of the victims of ecocides are actually from the global north, do you think it will scale through the ICC system? That is, at least, let's look at it from the global north and global south perspective. Thank you.
Thank you very much, Peter. Kevin, I think this is specifically for you.
Yep. So the first question is a really important one. And we shouldn't look at international criminal law and the prosecution of ecocide, or the prosecution of any international crime, first and foremost and always through the Rome Statute and the ICC. The ICC is just one court. It's an important one, but it obviously has very limited capacity to deal with any international crime, much less a new crime like ecocide. So, of course, these crimes can be prosecuted at the national level, and Stop Ecocide is very open, and to its credit, one of the reasons why they have been trying to increase awareness of ecocide is not just to incorporate it into the Rome Statute, because they're all very smart people and they know that that's not very likely, but to really catalyze efforts at the domestic level to create domestic crimes of ecocide and perhaps prosecute in domestic courts acts of ecocide. How optimistic we should be about this, I'm not so sure. So, for example, very recently, Belgium announced that it plans on criminalizing ecocide domestically. Hooray, we should all be excited about that. But then you look at the actual definition of ecocide, and it's even narrower than the one that is proposed for the Rome Statute. It doesn't have the severe, widespread, or long-term disjunctive test. It has the conjunctive one. It has to be severe, long-term, and widespread. Even more problematic, it excludes lawful acts completely. It only applies to unlawful acts that cause environmental harm, as determined by Belgian environmental law. And I'm not a Belgian lawyer. I don't know anything about how Belgium protects the environment, but my guess is that there are very few categorical prohibitions in Belgian criminal law that will capture acts that destroy the environment. So if we can convince states to adopt better definitions of ecocide, we should absolutely focus our efforts on the domestic level, insofar as they're going to just further dilute the concept, I think that's kind of problematic. The second question, is a really important one. If there was a crime of ecocide at the ICC, or if there's a crime of ecocide at the domestic level in probably global North states, how effective will it be? Who will be the defendants? I don't think one has to be particularly cynical about international criminal law to say that the likelihood of a really powerful American or British or French or German company ending up in the dock for ecocide is probably not very likely. It could very easily be actors in the global south, in the way that we have seen global south defendants being kind of overemphasized by international criminal law really since its earliest days. So it does open up another kind of tool in the toolbox. There's no reason why you couldn't prosecute an officer of a global north corporation for ecocide, but again, we get into all of the same limitations on the power of international law as the system that we've seen with all the other crimes. So not a reason to oppose ecocide, but it is a reason to be not skeptical, but cautious in our belief that it will have a transformative effect.
Thank you for that comprehensive answer, Professor Heller. I hope that answers your questions, Peter. I've got 3 questions here on the Q&A. I've got the first one from Lisa Madikian, who's actually one of our colleagues in the law school. I wonder, Lisa, if you want to answer your question, the question yourself live. If I can get let me just get the list of attendees. Probably for some reason, I'm not getting the list now. One of those.
Maybe we can summarize, Dr. Hobbs. We can summarize also the Communications question.
Okay.
Expedite the time.
Lisa,
okay, we have them with us, yes.
Lisa, you can talk if you want to, Lisa.
Hello, yes, thank you.
Okay.
My question relates to the relationship between the right to health environment and older civil and political rights. So some of these civil and political rights have formed the basis of environmentally friendly interpretations of human rights. And with the establishment of the right to health environment at the universal and regional level, and assuming that it will continue being progressively developed, this right over time, what do you think will be the relationship of the right to health environment with these older civil and political rights? And I'm thinking that in the context of human rights jurisprudence. Do you think that we will see a diversion between the two, where the civil and political rights will remain more anthropocentric and the health environment will be the main vehicle for a more ecocentric approach, or will we see a conversion between the different types of rights? Thank you. Thank you very much also for your presentations.
Many thanks, Lisa. Who wants to start on this particular question? Sara, I noticed that I think you were trying to type an answer.
Yeah, I was trying to. So thank you so much for your question, Lisa. It's extremely interesting. Well, indeed, yes, it's true that in the framework of the European Convention on Human Rights, civil and political rights were the ones that were used in order to, what you say, environmentally friendly interpretation, the sort of greening of human rights. So with the establishment of a right to health environment, the relationship, if it is a protocol to the European Convention on Human Rights, it really depends on ratification of that protocol. But once it enters into force, the European Court of Human Rights can apply these protocols, so per se, without a relation with other rights of the European Convention. And it's interesting because if you read the draft of the optional protocol, it is formulated in a very interesting way, taking into consideration also intergenerational equity. On the political issue, whether this protocol is really going to be adopted, that is another story. So we don't know yet. But my argument is mainly that the interpretation of existing rights can be more ecocentric, as the Inter-American Court of Human Rights did, using like the rights we have, but interpreting it and deriving this right from an ecocentric interpretation, using principles that are not like so weird in the jurisprudence. They have been introduced and adopted, and we see references to intergenerational equity. We see references to indubio pro natura in several courts, also at domestic level. And so this is the idea of cross-fertilization. Of course, as you caught from, and I think I can get from the question, it's obvious easier having a protocol or having a clear right in hard law envisaged, but there are also other means to get through interpretation to this result. Yeah, I hope I answered to your question. Thank you so much.
Definitely, thank you very much.
Many thanks for that answer, Professor De Vido. I'll move on to the second question. I can see time is moving on. So I've got a question here specifically for Professor Heller, and this is a question from Sara Dal Monico. She's wondering whether the destruction of natural heritage would amount to ecocide as conceived by the panelists, only in as much as it damages heritage of outstanding value for humans. Starting from the perspective that the definition is more anthropocentric than ecocentric. That's the question from Sara Dal Monico. Professor Heller?
I don't think so. I mean, the anthropocentrism of ecocide, is really about the cost-benefit analysis and the social and economic benefit. There still does have to be the requisite environmental damage. And of course, there is some damage to the natural environment when you're destroying natural heritage. But I'm not sure, unless that really rises to the level of severe and either widespread or long-term, it even kind of triggers the cost-benefit analysis at all. So I don't think that ecocide is really the location for dealing with attacks on the natural heritage. That said, we can certainly fold those kinds of attacks into war crimes if it takes place in an armed conflict, and even conceivably the crime against humanity of persecution, if the destruction of the natural heritage is tied to the desire to persecute a particular type of group. So I'm not sure this is one of the holes in international law that has to be filled by ecocide, and I don't think the way that ecocide is formulated would cover it.
Thank you very much, Professor Heller. I hope that answers the question. Last, we have a question on the Q&A from Anna Martin. And I'll probably want to start with Professor Spijkers on this one. So thank you for the presentation. The International Law Commission has backed a definition of the environment where the human and natural components are interlinked. Here we are hearing views about either anthropocentric or ecocentric positions as mutually exclusive. Do any of the panelists have any thoughts about the possibility that the anthropocentric, the ecocentric division be artificial? Can humans and nature be separated? And is it necessary to keep them separate? Otto, would you like to start on this one?
Yeah, but okay. I don't think a purely ecocentric approach to international law is really possible or even conceivable. I mean, we are human beings, right? So our interest comes first. And there's nothing selfish about this. I mean, other species, they act in the same way. And there's a lot of philosophical backing for that. So you take care of your own people, your own family, your own community first, and then you start caring about others. There's nothing selfish about this. So a purely ecocentric approach to international law, I don't think it exists. I don't think it will ever exist, and I don't want it to exist. I mean, we are humans, so it's all about our interest. And even provisions that seem to be ecocentric, they are really about interests of future generations of people. So our children and children's children and so on. Those are the ones that we care about, and those interests we have in mind. So I think all international law is anthropocentric, and it will always be that way.
Okay, thank you, Otto. Sara, do you have any more comments?
Yes, sure. Thank you so much for the question. Yes, well, according to one of the authors that I was mentioning before, De Lucia, he tried to overcome this binarism, anthropocentrism, ecocentrism, using these biopolitical analysis and looking into like overcoming this strict distinction between the two. That is why also my conceptualization goes a bit beyond this binarism, trying to see these patterns of domination, both within species and interspecies. And an ecocentric approach to law is not necessarily deep ecology, where, of course, in that case, philosophically speaking, is amazing. But as Otto was clearly saying, there are human interests, but an ecocentric approach to law tends to consider the patterns of domination, both within species and interspecies. So I like this when you say, yeah, I like what the International Law Commission did to include the environment, both human and natural components as interlinked. And I think this is really what is the path that is traced. Of course, it's not easy to apply ecocentric approaches to all fields of international law, because we have obviously in mind environmental law, clearly. But, and that is a research going on, so I cannot really have like very clear answers. But this idea is to look into the patterns of domination and repression and to see how to overcome those patterns. And obviously the laws are made by humans, that's clear. But it depends on the approach that we use in those laws. I hope it was clear enough, because it's still something I'm working on. But thank you so much for the interesting questions. That's one. It's not only your concern. It's my concern and also other scholars not to have this like binary distinction, anthropocentric or ecocentric approach.
Thank you so much, Sara, for that for the discussion. Professor Heller, do you have anything to add to this as well?
Yeah, just very, very briefly, because I think it's a really, really important point, and it does point out, and this gets to kind of Professor Spijkers' point as well. You know, there are inherent limitations to law. Law is inherently anthropocentric. It has to categorize in a way that philosophically we would all be very skeptical of. And I like to think of it, you know, in terms of ecocide as you know, it's an ecocentric definition of ecocide is also anthropocentrically necessary, because if the planet doesn't survive, humans don't survive. So it's not just about protecting the other critters, it's protecting the human critters as well. And one of the problems with carving out this massive exception for socially and economically beneficial development is that when you kind of combine that with all of the other potentially lawful acts of development, you get the end of the planet and you get the end of human life along with the life of everything else. So, you know, ecocentrism is necessary for anthropocentric reasons, just as it's necessary for ecocentric reasons. So we should be skeptical of that distinction.
Professor Hobbs, if I can have also a
Thank you
question
very
here
much.
for the panelists, maybe not to wrap up also the event.
Yes.
In dubio pro natura, and we have in dubio pro reo in criminal law, there may be these links between criminal law and international law. My question is about this in dubio pro natura, this tendency to have the ecocide. We speak also recently in international law about animal rights. So we have maybe power tendency to protect the animal kingdom, also in warfare, etc. So my question is, maybe this whole discussion about ecocide we unveiled today is another step towards seeing maybe the animal. If we have, let's say, this categorization, this ladder, the human being, the animals, and the plants, maybe the whole ecocide discussion comes to address, after the animal rights discussion, another layer of human rights, of rights discussion that should be unveiled before international law. So maybe your thoughts on this, whether it's the next step after animal rights.
I mean, it is a next step, but it's, I'm very skeptical of rights talk in general. There's a reason I'm not an international human rights lawyer, and it goes back to the first question, which touched on civil and political rights, but we could have mentioned economic and economic rights in particular, where you immediately get the clash of rights. You are going to have many states invoking the concept of an economic right to try to neutralize the rights of nature, and saying that, by adopting an ecocentric perspective, you're preventing us from, China lifting our people out of poverty, and that's a fundamental human right. And I don't see any easy way to reconcile those kinds of debates. So, I'm for anything that raises awareness of the rights of animals and the rights of nature, but whether rights is an effective legal tool, I'm more skeptical.
Thank you for that. Thank you, Solon, for your question. Oh, I can see. Okay, I can see a. Oh, I think I'm just going to ask a question before I can see Suman had already his hand up earlier. I just want to ask a question to the panel. In general, so the thought, obviously, Professor Heller, your definition, your sort of discussion regarding the definition of ecocide, I just wonder where you place it is in the overall picture, whether whether there is a possibility ever in the future of the ICC, of the Rome Statute taking on this new definition, or whether this whole project is more symbolic in nature and just trying to move the discussion forward, not so much going back to the sort of that distinction between anthropocentric and ecocentric, trying to fuse the two a little bit and maybe to think more about future generations, and therefore trying to develop a more ecocentric view whenever we deal with issues in relation to humans, so whether it is more symbolic than anything else. And the question for Sara is regards eco-feminism, how we can move the discussion forward in a context of ecocentrism in international law. Thank you.
Go ahead, Sara.
Thank you so much, Kevin. Yes, this is a very initial research I had, so you could find something in the article that you mentioned before on ecocentric approaches to law. What I could see is that ecofeminist approaches have not been studied from a legal perspective, but what I would like to apply is to see whether these concepts that were developed by ecofeminists who were not like lawyers, but studied the patterns of domination and oppression, whether this could turn into a reflection from a legal perspective. To say it in other words, can we apply ecocentric approaches to law, even though I agree with what Kevin was saying about anthropocentrism and ecocentrism, I also agree with that, but can we see and look into ecocentrism and apply that to other fields of law, not necessarily environmental law? So looking at subjects of international law, looking at state responsibility, the use of force, for example, and in that sense, for example, the use of certain weapons, and looking at how certain weapons are used and violate international rules. So that's a very initial thought, because as I could see, at least as far as my research has gone so far, ecofeminism has never been really looked at from a legal and international legal perspective, except for one thought by an author, but just one I could find at least. Thank you.
Thank you, Sara. Professor Heller?
Well, I can be very quick. Nope, not going to happen. I don't see there ever being an operative crime of ecocide purely in international criminal law in terms of international organizations. At the domestic level, I can see there being progress. I can see some states adopting a more ecocentric approach, but I do think it's largely symbolic. But that doesn't mean that it's meaningless. I mean, it is good that we have raised the international profile of ecocide in a way that it hasn't before. It's just if we judge it by solely, will it ever be actually incorporated into the Rome Statute and prosecuted? Like many areas of international criminal law, we're fairly bound to be disappointed.
Yes, yeah, thank you very much. I have a question first on the Q&A, and then I'm going to ask, unless that was an old question, Simon. So I've got a question here from Alexandra Hunes. I hope I'm pronouncing it correctly. And Alex is from the University of Wisconsin. So he's asking a question about rights of nature in Latin America, deeply entwined with rights of indigenous peoples. Could this not be the path by which ecocentrism enters international law? Thank you very much for that question, Alexandra. Does anyone want to start on this one? I don't think we touched on indigenous peoples and ecocentrism in our discussion. Sara, yes.
Yes, thank you very much, Alexandra. Yes, indeed. And precisely also the judgment that I mentioned of the Inter-American Court of Human Rights started from the rights of indigenous peoples, but then the legal reasoning went beyond. And as autonomous rights, the conceptualization and the argument that you can find in reading this judgment is that the protection of the environment consists in the protection of all the elements. So also what Solon was saying before. So all the elements, forest, sea, rivers, natural features, human and no human beings. So yes, that could be a good entry point. And indeed, that was the entry point for the judgment by this regional court. Thank you so much.
Thank you, Sara. Otto?
Yeah, I'm not an expert on indigenous rights, but I do find this a little bit problematic to always assume that indigenous people, they very much favor this approach. I think that's a bit of a stereotype, and it's not really fair to the great variety of opinions that exist in the indigenous community, because I know that many indigenous traditions and cultures, they don't really have this rights-based approach, or human rights-based approach, or rights of nature-based approach. They don't think in terms of law, in terms of rights and obligations. So this whole rights of nature concept, I don't really think it is it fits so well with indigenous culture and views and approaches. I think that's a bit of a stereotype, so we have to be careful with that.
Yeah, thank you for that thought. Professor Spijkers. Professor Heller, do you want to add anything to this? The last question that I have, apologies, I was muted myself. The last question I have on a Q&A is again from Simon Saruba. He previously asked a question regarding plastic. He's now in the context of ecotourism. Can we do something with respect to ecotourism in agriculture for upgrading our plan regarding international law? Do any of the panel have an answer to that? Seems to be quite a specialized area of international law. I think Simon, Kevin, Sara, do you have any answers to that? No, I think Simon, that sounds quite a specialized area of international law. However, got last question, I think, before we leave, from Kim Eriksson. Is it a possibility to adopt a distinctive emblem of protection for the natural environment under international humanitarian law, i.e. natural heritage site and case of widespread long-term and severe damage, similar to the way IHL offers protection for cultural heritage sites? Professor Heller, I'll give you the floor for this one.
No, I mean, it's a really cool idea. There certainly isn't any reason why we couldn't. And actually, you can see the kind of attraction of, particularly special parts of the natural environment. The practical problem is, in theory, when you're engaging in combat, you can avoid killing civilians. In combat, you can't avoid harming the natural environment. It is an inevitable part of warfare. So as long as warfare exists, there will be some damage to the natural environment, which is why we tend to focus on don't cause too much damage to the natural environment. But I kind of like the idea that there's some not just kind of culturally priceless parts of the world, but actually kind of environmentally priceless parts of the world. I don't know whether you could sell states on that, but again, I think it's a really cool idea.
Thank you, Professor Heller. Professor Vido, Professor Spijkers, do you want to add anything to that? Okay, then. Okay. All right. Thank you very much for your presentations. Thank you for the participants as well to take part in this event and for all your insightful questions. I look forward to see and to hear from many of you. As I said before, we'll be put the recording in our YouTube website and in YouTube channel, and possibly share the link with everyone who took part in the event. And
on behalf of the BUL International Law Group event group, to wish everybody a festive season, a new year. We're going to be back in the new year with more events, so stay tuned with us.
Thank you, Solon. Thank you very much for our three speakers, Professor Spijkers, Sara Vido, and Kevin Heller, and especially Kevin Heller for such a late joining us to this panel. Thank you so much. Thank you, and have a good Christmas break, everyone. Thank you so much.
Thank you very much. Thank you. Bye-bye. Thank you.
Bye.
Thank you. Happy New Year.